I was so appalled by this, I ran by a couple other referees to hear it. That's an absurd request. You're not going to run the kids' lives at her house, as she is not going to run the kids' lives at his house. He is not going to demand that the kids have pictures of him put up in the house. All right.
He does not care about her relationship. He cares about the best interests of the children, like he always
That's
has.
right.
Okay, just for the record, referee, what were the other referees that you ran the issue by?
None of your business. It looks like we have everybody present. Can everybody hear me? You can shake your head.
I can, Your Honor.
All right, we're here in the matter of what is Haddad versus Haddad, case 22-2513-DM. Plaintiff, formerly Miss Haddad, is present with her attorney, Mr. McConnell. We have Mr. Haddad represented by Miss Ross. There are a couple motions filed in this case. It started out with a motion from the plaintiff through Mr. McConnell for modification of parenting time. There's also been and I've read that, I've read the response. There's also been a motion filed for appointment of a guardian ad litem for the children, and that was filed by defendant's attorney, Ms. Ross. So I've read the motions, I've read responses, whatnot. The long and short of it appears to be that the parties agree that the court needs to set some kind of specific parenting time. But I'm going to let you start out, Mr. McConnell, and have a brief statement if you'd like.
Yeah, thank you, Your Honor. I would I know the court reads all the filings and the court's not interested in attorneys regurgitating what they've already written and filed. I just want to focus on the response.
Yeah, please don't do that.
The response is it makes the point that we're trying to make in terms of our motion, which is we believe that the defendant needs some boundaries. We think that the evidence we provided can show the court that this defendant is simply trying to exert a certain inappropriate level of control over the plaintiff's household, her separate household, and how she's going to co-parent these kids. We don't think he's interested in co-parenting. We think the evidence shows the court that he's interested in solo parenting how he thinks it should work. And so our motion is about just modifying the current parenting time order to set some boundaries and to kind of limit the efforts of the defendant, which again, we think we provide the court with evidence that there's evidence here that this defendant needs some boundaries. And that's what our 6 specific asks are for in terms of modification of the current parenting time order. We're not looking to change a whole lot. We're just looking to set some boundaries. And I think if the court wants me to go through the 6, I can go through the 6.
Let me just start out with this in some kind of a reasonable manner here, okay? The first thing basically that you've asked for, and that I think Ms. Ross even would agree to, is that there needs to be a change to the parenting time language to set specific parenting time. Now, the court does not, I mean, if parties agree, no matter what they put in a judgment of divorce, that they think that they can live with in parenting time, I certainly wouldn't mess with it. However, this parenting time order is, I think I don't know what you characterized it at, but it was characterized as convoluted or something. And from my perspective, that's probably a good characterization of it. And I think, Ms. Ross, you even agree that we need to do something to have some certainty with parenting time. I mean, there's parenting time provisions where she gets the children in the summer, but he can show up and be there for part of it. And I don't even know how long or what, but the mother still, if it's a mother's time, then she still dictates. But I mean, those kind of things. Isn't that the long and short of the first part of your motion, Mr. McConnell?
Yeah, there's a shared parenting time provision. We want to get rid of the shared parenting time provision. We don't think that.
And we need to set, and that's what I intend to do, because it's not a workable solution to parenting time, I do not believe. Ms. Ross, do you stated in here, even in your response, defendant agrees the current parenting time should be modified to prevent further parent alienation and to correct current parenting time inequities caused by the ambiguity and plaintiff failure to act. That's the only way. I mean, I'm not saying you're right in half the stuff you said there, but we do need to modify parenting time and have certainty.
Yeah, yes, referee Fredericks. I would agree to that, but what we do dispute is the reasons why the original agreement that Miss Blair agreed to is not working, is not the fault.
Doesn't matter what the reason is.
I agree. I agree it doesn't matter. But
Doesn't
Mr. McConnell thought it did when I spoke to him before, so I just wanted to make clear that he disputes the reasons why it's not working, disputes what she's saying. And yes, it does need to be reworked, but I would disagree with Mr. McConnell's claim that they're not asking for a significant, to change a whole lot when their proposal would reduce his shared parenting time with the boys by 30.22%. He is a long distance parent.
Yep.
So in the public policy favors giving as much frequent and liberal parenting time as possible to foster and encouraging a relationship with
Yeah.
the father. And by her requesting all of the spring breaks as the change and reducing what would be his shared parenting time under the original agreement, it's taking away the intent of the original
What do you
agreement.
mean reducing his shared parenting time? Like
If
he
they
can show up-
eliminate the shared parenting time, he's losing what they intended he would receive by 30%.
I have no
Well,
idea where
bottom
she's
line
getting
is,
that.
the bottom line is, we're gonna start out with a settlement conference between Mr. McConnell and you, where you're both gonna send in what you think is appropriate for parenting time. The bottom line is also that Mr. Haddad is a long distance parent and he cannot have every other weekend and that kind of stuff, all right? There is summer, there is the winter break, there is a spring break. There may be, I don't know, there may be a long weekend sometime in January or February and this kind of stuff. That's basically what we're playing with, because he's not gonna just get every other weekend and stuff like that. That's just not possible. And it also is not going to interfere with the school, with what the kids are doing at school. And he's not going to get all of the time that I just mentioned, because she gets a chance to have some weeks to have parenting time in the summer too. She's not just going to be the school mother, okay? And that he gets all the fun time. So we're going to deal with that, and both of you are going to send something in to me with your proposals. My clerk is going to get to you. We're going to set up a settlement conference within a couple weeks. I assume that would work for both of you. We'll talk about it. If we can't come up with a solution, we'll have an evidentiary hearing on it. That'll be fine, all right? There's no huge rush, because the major time that he is going to get is going to be the summer, and it's going to be a question of how much. All right.
Your Honor, I totally agree with that. I will get this settlement conference calendared with your clerk. I just want to be clear that as part of the specific schedule, we're also going to be proposing certain parenting time, I don't want to call them restrictions, but maybe just things that we'll all have to live by as we try to co-parent. That's going to be part of our settlement proposal.
And I'm also going to tell you, I'm going to deal with the times probably separate from this, from what you are requesting, because number one, I want both parties to understand, I'm not going to micromanage every minute that these kids are with the other side. All right. You got to understand that there are certain things that are just reasonable that are out there, and I'm not going to micromanage this. All right, but we'll get into that in a minute. All right. Do you understand that, Ms. Ross, what I'm expecting?
Yes. Should I respond to Mr. McConnell's statements or?
Well, first respond to mine. Do you have any problem with what I'm suggesting? And I hate to tell you, but it doesn't matter, because that's what I'm going to do, but I'll give you an opportunity to put something on.
No, we have no problem. In fact, I had suggested this to Mr. McConnell yesterday, that we just agreed to proceed with either mediation or agreeing to the proper cause being there, and then working on a proposed new agreement. So I completely agree with that, but
And don't let me, and I don't mean to interrupt, but quite frankly, If you guys want to do mediation, I'm not going to stand in the way of it. All right, if you guys agree on a mediator, but I'm not sure that you can even agree on a mediator. And so I'm going to set something up for some kind of a settlement conference. We'll probably have it in a couple of weeks, right? Give you enough time so you can each talk to your clients and draft something. I would like something drafted. I'm not going to make you come over here, Miss Ross. We'll do it via Zoom.
I am in Grand Rapids, but Zoom is
are?
fine as well.
Are we-
I'm work remotely. I am with the firm, but
All right.
I'm
Well,
handling
maybe
cases
it'll
here.
work out best if you guys both showed up here. I like it when both do, but I had your address in Troy, so I certainly wasn't going to make you drive here from Troy for it. But if
Are we
you're
set-
local,
Are we setting a date and time right now, Your Honor?
I don't, huh? Can we do an?
I've got a couple of things coming up in the summer. I don't want to have a date set that I have to later have to try and get rescheduled if we can do it now.
I'm
You
pretty
mean you got-
busy
You got
too.
vacation, you mean? You're not gonna reschedule your vacation so you can meet with me for an hour?
Only if you order me to.
I'm not going to. Do we? I'll. couple
August
weeks.
15th at 9 o'clock.
I have a settlement conference there or via Zoom with Judge Ackert at 9:30.
I doubt we'll be done in a half an hour. We can
Right.
start at 8:30, but
August 20th at 10:30.
What was that? I'm sorry.
August 20th, 10:30, Ms. Ross, you gotta chime in here too. I don't wanna mess up.
August 20th?
Yeah,
I've got a deposition scheduled. I can't.
well, for Pete's sakes. Yeah, now you're the,
What date works for you?
well, what,
August 27th.
Jesus, it's out a month from now. August 27?
That works for me.
I'm available the 27th.
Rachel, are you available?
In the afternoon. This is a conference between us. They can be here in the courtroom, but you're gonna come into the back room and meet with me.
Yeah, do you want the parties there?
Up to you. I don't wanna have Mr. Headed have to fly here from Washington.
Oh, of course not. Yeah, but
Okay.
whatever.
So, I mean, I'm gonna tell you quite frankly, we're gonna meet in the back room. I'm gonna give you my thoughts and you're gonna give me your thoughts and you're gonna go talk to your clients. If we reach an agreement, it would be nice to put it on the record, but again, I'm not gonna have Mr. Headed fly here for a settlement conference for an hour. He might be available via Zoom if he wants, or even just be available to Miss Ross for him to be called. And we can determine, if there's a settlement to put on the record, she can call them, they agree to it, we'll go on Zoom and we'll put it on the record. All right. So, and I don't have to have it way in advance, but I'd like you guys to exchange this document as far as what you think is appropriate for parenting time, at least a week in advance, so that you guys can talk to your clients about it and stuff like that, okay? And again, if you guys would rather go to mediation, you can do that. But I'm not going too far with that. All right, now, you've been asking for a ton of other stuff. Let me also, maybe before we go too far, Ms. Ross has asked for a GAL, you oppose it, all right? Ms. Ross, you may briefly talk about that if you want.
Yes, Your Honor. It has come to Mr. Haddad's attention that the children are struggling with certain boundaries that are being violated by Miss Blair's current boyfriend. They're expressing distrust.
What
over it.
boundaries are you talking about?
Specifically, the way he refers to them, certain pet names and like affectionate names.
Now, do you understand that I find that to be an absolutely absurd request on his part? Absolutely beyond absurd.
Because the children don't feel comfortable around her boyfriend. That's absurd.
It's absurd that if her boyfriend says, "Hey, pal, come on over here," that he has, I'm not gonna order him to refer to him as a as a specific name. In fact, I was so appalled by this, I ran by a couple other referees to hear it. That's an absurd request. That he can't, I mean, I'll tell you, he can't refer to him as a MF. I'd like to be able to say it, but if that's his pet name for it, I'll stop that, and that kind of stuff. But he probably calls him Wes sometimes, and at other times, hey, bud, come here. That is, that is trying to micromanage this, and that is an absurd request. Go ahead.
Okay, well, the request is for guardian ad litem, so the child could speak their feelings without a fear of the parents or having to
What
discuss it
feelings
with
do
the
they need
parent.
to speak? We're just dealing with the parenting time, which is basically kind of set. I'm not gonna make a huge amount. It's not gonna affect an established custodial environment, but I mean, we've all agreed, there's only so many times that he can have the children, all right? And his time is limited by summer, spring, winter, maybe Thanksgiving. And that's what we're dealing with.
This is coupled with other discomfort by the children, which includes them being forced to go to his house when they don't want to. And there's a familial intimacy that's being imposed on them that they don't want. Just because he wants to have this really chummy relationship with them does not mean the children want that, and they shouldn't be forced into it by this third party or by their mother.
My feeling is that your client's filling the kids full of that, all right?
Well,
That
we
he
object to
doesn't need
that.
go there. Your request in here that says he's not to drive the kids anywhere. That was one of them. She must drive him, or family relatives and things like that. That's an absurd request. He's an adult. Does he have any, has he got a drunk driving that he doesn't have a license? Things like that?
He does
He's
have a
adult.
history
He's
of driving
part
without
of
a
the
license.
family. You're not going to restrict I don't know if I'm calling him a stepdad. He's not really a stepdad and this kind of stuff, but you're not going to run the kids' lives at her house, as she is not going to run the kids' lives at his house. He is not going to demand that the kids have pictures of him put up in the house, all right? That's another absurd request. If he wants it, fine. If he doesn't, but he's not gonna micromanage her life there. She has another individual. I know he wishes that individual wasn't there. There's nothing that you have pointed out to me that he is somehow a bad individual. I don't know, and I guess I'm kind of asking, but if they're gonna end up together and stuff like this, those sort of things are absurd requests.
Okay, just for the record referee, what were the other referees that you ran the issue by?
None of your business. I'm just, we talk about motions sometimes, and I'm going, what do you think of this? Geez. I mean, I don't need that. I'm not making a decision based on what I ran by another referee. I'm making a decision that I think that's an absurd request, all right? And if any alienation, I'm starting to worry about alienation, because he's telling the kids, hey, you don't have to go to that guy's house. She's moved on, okay?
He does not care about her relationship. He cares about the best interests of the children, like he always has.
That's right.
And that's what the evidence will show.
Are with her a majority of the time, and as long as she's not doing anything appropriate, and I haven't heard anything that she's doing inappropriate. I haven't heard anything that she is doing inappropriate. If she marries this man, what do you want? Kids can't be around him. He can't call him pal. He can't drive them. They're absurd. You can appeal this, and I welcome you to do that, because it'll go nowhere. All right. This kind of micromanaging, this kind of the kids being used that, oh my God, your mother doesn't have a picture of you in the room with me. I'm going to say that to your mom. And he said in there that she can't let him drive the kids anywhere. This might be a life partner. I don't know if it is or not, but it seems like it. And you have pointed out nothing that's bad with him, nothing that he's even done bad.
Well, when there's an evidentiary hearing on the parenting time, that will all come out.
It will not come out about alienation. This isn't going to be about alienation, because Mr. McConnell, I'm going to stop him, because he has a better claim of alienation from what you have filed.
Your Honor, what evidence have you taken in terms of testimony? Yeah,
I
you
haven't.
exactly. So how would you know whether
I'm
there's been
taking your
alienation?
statements that you put in here. You put in here that the kids are being, he may call them a pet name that he is not willing to, I marked it in here. All right. Let me see. Kyle is to address the boys by their birth names, birth given names, Blair and Wesley or Wes. He is not to call them by any other name, such as Buddy, or any name that would convey a closer relationship than I permit them to have with the minors, than he permits. That is not part of this. That's your statements that I'm dealing with. I don't need to have an evidentiary hearing unless you're putting stuff in here that doesn't belong in here.
Mr. Haddad will present evidence regarding the factors related to the best interests of the children in terms of Miss Blair's inability to put the children's feelings, needs, and comfort above.
This is not a custody hearing. This is not custody. You understand that, don't you?
I know the standard, referee Fredericks.
This is not a custody hearing. If we cannot set an appropriate parenting time, which is like on, June 3rd till August 4th, he gets them at Sunday till whatever. That's the stuff that we're doing as far as parenting time. All right. If you think that you're going to try and change custody with that, you're wrong. Because there's nothing been presented and there's nothing that even comes close to Vidvarka. Go ahead. Anything else? You can make the record. That's why I put you guys on last. I knew that this would happen, and you can make a record for some things.
Your Honor, or referee, it's clear that you've made your decision on this.
I made my decision as far as this is a parenting time thing.
Okay.
And that's what we're dealing with. Anything else you want to put on?
No, we'll save it for the evidentiary hearing, Your Honor.
Well, you realize I'm not scheduling an evidentiary hearing on parenting time unless and until we don't reach something through a settlement contract.
I understand that.
All right. Mr. McConnell, anything you'd like to add?
I just would respectfully request the court to deny the motion for the guardian ad litem to be appointed. We can think of nothing more having long-term impacts on these two boys than having a guardian ad litem when we have no record of abuse or neglect before the court. We just don't think it's healthy to have these boys go through that.
I'm going to not appoint a guardian ad litem at this time, although depending on how our settlement conference stuff and goes like that, maybe it's best to defer. Okay, if it becomes apparent that we need some guardian ad litem, but I'm certainly not going to appoint one now, not for parenting time at least.
Thank you, Your Honor.
Anything else, Mr. McConnell?
No, Your Honor.
Anything else, Ms. Ross?
No, thank you.
We'll see you on the 27th.
Everybody have a good weekend. Thank you.
Thank you, you too.